Well, okay, we're here again today to discuss trials in criminal court. So, up to now we've been talking about a lot of preliminary matters, and so we're going to assume from here that we selected a jury and went through that process that we've discussed over the last few days, and then now moving on to the actual trial. Important things I want to emphasize is, the role of the prosecutor, the defense attorney, and the judge, as well as the jury. Important thing to know starting out is the burden of the proof is on the prosecutor. They have to prove their case beyond reasonable doubt. This is a doubt based on reason, so that means that it has to be a pretty substantial level of proof, a lot more than, say, like a fender bender car wreck case where somebody claims that they hurt their back or something like that. The only proof needed in a civil case is just over 51%, and that's the old where the lawyers are standing up in front of people, and if you just tilt the scales of justice just a tiny bit in favor of the plaintiff, then that's enough to award judgment to the plaintiff. So proof beyond a reasonable doubt is radical. I mean, it's like a very large amount, very large quantity of evidence. I don't want to try to quantify it in percentages and that type thing, but it is, the state does have a pretty substantial burden of proof. And so because the state has this heavy burden, the state has the first opportunity, and so we put the state gets to go first and last, okay? And so what we mean by that is they get the state makes an opening statement. It's not an opening argument, it's an opening statement. These opening statements that are made by the lawyers are trying to give the jury a bit of a roadmap over what to expect in the case, what to look for. The defense can make a statement as well. Sometimes they waive the right to make a statement. Sometimes they reserve. Sometimes the court will allow defense counsel to reserve the right to make their opening statement after the prosecutor is done submitting all of their evidence. So once the beginning statements are made, the judge is given preliminary advice to the jury called instructions, and then it's up to the prosecutor to start presenting that evidence, okay? And it's just an unqualified confession by a defendant is usually not enough to convict them of the case. There has to be some independent physical evidence. So there is a big burden on the prosecutor, and we take that for granted a lot of times. Of course, they have like a legion of troops to call on. The city police, the county sheriff, the state police, all these experts, even the FBI. I've seen the FBI testifying cases. And so, you can have a lot of assets out there that the state can call upon. But the important thing to keep in mind, too, is that the state gets to go last. And what that means is even after the defense has called all of their witnesses, put on any evidence that they have, then the state has the right to put on what we call rebuttal evidence. And rebuttal evidence can only come into play if the defense chooses to present evidence, okay? And the thing about that is the defense has no duty in most cases to present any evidence, okay? You have the right to remain silent in this country, and that means you can stand trial and your lawyer will not put on a shred of evidence. Sometimes that's a good idea because you can really hurt yourself, sometimes more by putting on evidence than you can help yourself. And so that's another thing. But if if the defense does put on evidence, then the prosecutor can present rebuttal evidence. Now, there is also a thing called rebuttal, and I think there's another T in there. Something's not right. It doesn't look right. Well, anyway, basically, so the defense, which we use a triangle to mean the defense, they present it, but I'll tell you, once again, the prosecutor gets to go again because the prosecutor always gets to go last. So we want to make that very clear, is that the case always involves the prosecutor being the last person. And a lot of times the judge will say anything else, the prosecutor say, no, we're finished, thank you, Judge. And so basically what you're looking at here then is the whole case from soup to nuts involves the state gets to go first and last, and the defense can present evidence or not. They don't have to. The defense may not present any evidence. Now the problem with that though is there are some certain situations where the defense does have to. In these modern times, the defense does have a duty to present evidence. Any kind of situation where the defense is saying that there is a problem with mental illness, the defendant is mentally ill, the defense has a duty to present evidence. Okay, affirmative defenses, and this would be, let us say, like alibi. Okay, I was somewhere else. Well, you're going to have to put on some evidence to that extent. Okay, somebody stole my face. Whatever. Any kind of an affirmative defense. So if you've pled an affirmative defense, like self-defense or something like that, then you probably are going to have a duty to present evidence to back that up. Okay, so if you've just stood there silently, didn't enter any kind of plea, because the judge will actually enter a not guilty plea for you. So you really don't have to do anything. You can just go, and I've seen cases like this, where the defendant just goes, sits and listens quietly, oftentimes found guilty, sent on his way, but they have the right to do that. Now, I had a case like that one time, and I could go on and on. I could regale you with stories. But this one case that I had this guy that got into a domestic violence situation with his wife, and his wife called the police, and he was so upset at his wife that he basically took it out on me. So this is the guy that comes to court filthy, will not take a shower, sitting in jail the whole time, can't make bond, he's like he's on a hunger strike, a dirty strike, where he will not shower, will not be clean, coming to court. So back in those days, we had a lot of bailiffs were retired police, and so they'd be like a 50 to 60-year-old policeman that would be in charge of security in the courtroom. And so this one older bailiff in the courtroom, he would come in and he would have this some kind of spray, like a air freshener spray, Lysol and all this kind of stuff. So I'm having to sit next to this guy, and it's killing me. It is nasty. The guy stinks so bad because he's been sitting there like 3 months. And everybody in the courtroom can smell it. The judge is like 50 feet away. He can smell it. The jury is like 5 feet away. If you're going to find him guilty, that's enough reason right there. Nobody ever does anything, but the guy smells bad, So the judge has the bailiff go down there and just keep spraying around this guy and all over the place, because the guy was angry because the wife turned him in for abusing her. So it's one of those things. Obviously, the guy didn't do very well in his case. But I think he kind of hurt himself by just his whole attitude and everything. But he would just kind of like sit in the corner and pout, wouldn't say a word. We couldn't put on any evidence. I couldn't really do anything for him. He's just a recalcitrant defendant, would not cooperate at all. and to the extent that he wouldn't even cooperate in his cleanliness. So that's one case. Like I said, though, I could go on and on and on. I've tried 100 cases easily. I lost track a long time ago. I've won a few, lost a few, and it's tough to win as a public defender. And so it's just one of those situations where you've kind of got the deck stacked against you because, like I said, the prosecutor has these legions of police and scientists and all this lined up, and you're dealing with a person who has no money, no assets, no way of defending himself, and very limited in terms of resources that you can use to try to help him. You can go to the judge, you can ask for special things like mental health examination. Sometimes the judge will grant those, a lot of times he won't. So this is another situation where it helps to be rich. I mean, if you look at the OJ case, or even if you look at this Zimmerman case recently, even though this guy was not rich, he developed broad support from the gun lobby, and they backed him to the hilt. Way upwards of $500,000 is what I heard was donated to help him. So you got to have a lot of money to defend yourself. Let's just put it like that. And if you don't, a lot of bad things can happen. One thing I would say is that one of the good things that's going on nowadays is this Innocence Project. This has really taken off, and that is Barry Schecht, who worked on the OJ case. He actually earned several $1 million in that OJ case, and he just put that all right back into this program that he started called the Innocence Project. So very interesting situation. Way over 300 people innocent on death row or in serving long stretches in prison have been freed because of the work done by the Innocence Project. So I would strongly urge you to look that over, www.innocenceproject.org, and you can just Google on that, and you'll just see pages and pages and pages of information, all very interesting about how the poor a lot of times do suffer in these kind of cases. Hope you got something out of this. Main things I wanted to stress is that the prosecutor does have a high level of proof that he has to meet, but he does have a lot of assets to help him meet that proof. Plus, he gets the opportunity to go first and last in the trial, and the defense has to go in the middle. Any questions, any problems, always feel free to contact me at robdawalt@me.com. Thanks a lot.